Hello, everyone, and welcome to Uncivil Law. For today's case, we have the case of Chong and Marie Yim versus City of Seattle in Washington. This is a case dealing with housing discrimination. Seattle passed a rule by municipal code that basically said that any landlord must rent a property to the first tenant that comes along that is qualified. So if you have a bunch of people that apply and they're all qualified to rent, you must rent to the first person in time who is eligible. This was meant to prevent discrimination. This rule exists in many places within the United States, but this is a relatively recent change in Seattle's law. And so the state of Washington is being asked to analyze whether or not this is constitutional. Does it improperly burden on a property owner to require them to rent to the first person who comes along who is qualified? And what's really interesting about this is that it's a fairly serious change in the law for Washington. So we're going to read this and see how the law has changed, so let's get started with this. This case concerns constitutionality of Seattle's first-in-time rule. Broadly speaking, the first-in-time rule provides that Seattle landlords seeking to fill vacant tenancies must provide notice of their rental criteria, screen all completed applications in chronological order, and offer tenancy to the first qualified applicant subject to certain exceptions. The plaintiffs are Seattle landlords who claim that the rule facially violates constitutional rights. The trial court ruled that it was unconstitutional on its face because the rule facially affects a per se regulatory taking in violation of the state constitution. The rule facially infringes on plaintiffs' substantive due process rights in violation of the state constitution and violates on free speech rights. The Supreme Court grants direct review and now reverses on the state constitutional issues. The district court said that this was unconstitutional, but the Supreme Court of the state says it is constitutional, and they're interpreting their state constitution, so they're the highest authority with respect to that issue. So this is the new guidelines as it relates to the Constitution of the state of Washington. The first-in-time rule provides that when Seattle property owner seeks to fill a tenancy, the owner must first provide notice to a prospective occupant of the criteria the owner will use to screen prospective occupants and a minimum threshold for each criterion, as well as all information, documentation, and other submissions necessary for the owner to conduct the screening. Next, the property owner must note the date and time when the owner receives a completed rental application and screen completed rental applications in chronological order. If, after conducting the screening, the owner needs more information than was stated in the notice, the owner must provide all prospective occupants in writing by phone or in person what additional information is needed. Finally, the property owner must offer tenancy of the available unit to the first prospective occupant meeting all screening criteria necessary for approval of the application. The first qualified applicant has 48 hours in which to accept the offer of tenancy. If the applicant does not accept, you go to the next in line. The first-in-time rule became effective on January 1st, 2017, although compliance was not required until July 1st, 2017. On August 16th, 2017, the plaintiffs filed a First Amendment complaint seeking declaration the city's rule violated takings, due process, and free speech clauses of the Washington State Constitution, and also seeking permanent injunction forbidding enforcement. As to the first issue, this court has always attempted to define regulatory takings consistent with the federal courts applying the takings clause of the Fifth Amendment. The federal definition of regulatory takings has been substantially clarified since we last considered the issue, such that the legal underpinnings of our precedent has changed or disappeared altogether. It has not been shown that we should adopt a Washington-specific definition as a matter of independent state law at this time, and therefore we adopt the definition of regulatory taking set forth by the United States Supreme Court in Lingle versus Chevron. So the United States federal Constitution gives a floor, not a ceiling. So what the Washington Supreme Court is talking about here is that they have their own definitions in their own Constitution. So it could grant more rights than is available under the federal Constitution. So the question is, does Washington's guarantees merely the same as the federal Constitution, which is one possibility, or does it provide something more than what the United States Constitution provides, which is another possibility? Here, the Washington Supreme Court is saying, no, our constitutional text means exactly the same thing as it means in the federal constitutional text. And Washington Supreme Court, as judge of its own constitution, is allowed to do that. Regarding the second issue, as analyzed more in detail in our opinion for Chong Yim versus City of Seattle, This court has always attempted to apply a standard of review to Article 1, Section 3 substantive due process claims that's consistent with use of our federal courts by applying due process clause of the 5th and 14th Amendments of the United States Constitution. We therefore apply rational basis review to plaintiffs' substantive due process challenges to the law. The plaintiff's facial takings and substantive due process claims cannot succeed unless plaintiffs have shown no set of circumstances in which the rule as currently written can be applied. They cannot meet that burden on the record presented, while the city has the burden of justifying the fit rule for purposes of plaintiff's facial free speech claim. We therefore reverse and remand with instructions to grant the city's motion for summary judgment. Next, the Supreme Court of Washington is going to talk a little bit about the difference in regulatory takings in eminent domains and when regulatory takings becomes too much and therefore the government does or does not owe compensation. So let's get into when regulation needs to be compensated and when it doesn't. Both the federal and state takings clause allow for claims of inverse condemnation by excessive regulation, otherwise known as regulatory takings claims. Regulatory taking claims are based on the premise that while property may be regulated to a certain extent, if the regulation goes too far, it will be recognized as a taking. When a regulation goes too far, it becomes a de facto exercise of eminent domain, even though the private individual still actually owns and possesses the property. Regulatory takings may be either per se or partial. A per se regulatory taking is found where a regulation's impact is necessarily so onerous that the regulation's mere existence is, from the landlord's point of view, the equivalence of a physical appropriation. As a matter of federal law, such categorical treatment is appropriate for only two relatively narrow categories of regulations: regulations that require an owner to suffer a permanent physical invasion, and regulations that deprive an owner of all economic benefit. All other regulations are susceptible of partial regulatory takings, which federal courts decide on a multi-factor test applied on a case-by-case basis. The plaintiffs here claim that the first-in-time rule effectuates a per se regulatory taking because they argue Washington courts recognize another category of per se regulatory takings, which includes any regulation that destroys one or more fundamental attributes of ownership, such as the right to possess, exclude others, and dispose of property. We now clarify that none of our regulatory taking cases have reported to define regulatory takings either per se as partial as a matter of independent state law. Since we last attempted to do so, the federal definition has been clarified substantially, as now clearly inconsistent with the definition set forth in our precedent, overturning precedent. Thus, the legal underpinnings of our precedent have disappeared, and it's not been shown we should adopt a Washington-specific definition of regulatory takings as a matter of independent state law. Therefore, we disavow our precedent, adopt the federal definition of regulatory takings, and hold the plaintiff cannot show the first-in-time rule facially meets this definition of the record presented. The United States Supreme Court at least takes it fairly seriously when they're overruling precedent. I mean, this has been a big battle between the right and left-leaning parts of the Supreme Court in the United States system recently. So, how big a deal is this? How much precedent are we overturning exactly? The one case, two cases? How much a change is this? How much precedent is being disavowed exactly? For that, we can look at the appendix. The following is a non-exclusive list of Washington Supreme Court cases that may no longer be interpreted as requiring a heightened standard of scrutiny. How many cases are there? Oh. 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 That's a lot. Okay. So as it turns out, it's all the cases. Okay. That was a nice 100 years worth of precedents that just disappeared in one single flash. So hope no one was, real comfortable with those 100 years of precedent because they're gone now. Although we have never defined regulatory takings based on independent state law, our precedent may have appeared to do so. I love that statement because it's basically saying every court and every attorney in the entire state of Washington for the last 100 years, you all have been mistaken for 100 years over these dozens and dozens of cases. It may have appeared that we did this, but we never did this. So I don't know if this qualifies as gaslighting or what, but it's every attorney in Washington is now you've been wrong for decades. How, you fools. Okay. Regrettably, this court has added to the confusion by occasionally characterizing our cases as setting forth a state regulatory takings doctrine. Yes, I would think that qualifies as confusing. If you, the state Supreme Court, say that you're setting forth a state regulatory takings doctrine, if I, an attorney in the state of Washington, were reading that, what I'd interpret that to mean is that you're setting forth a state regulatory takings doctrine. But apparently, I was misreading it all this time. Somehow. Our attempts to articulate a test for when regulations cross into the line into regulatory takings have always attempted to achieve consistency with federal law, not to set forth an independent state law doctrine. Is it just me, or does the Washington State Supreme Court seem to be protesting a bit too much? I think if they protest a bit too much, I think maybe, yeah, we didn't change the law. This has always been the law. Move along. Even though the United States Supreme Court held in 1922 that a police power regulation becomes a taking if it goes too far, the United States Supreme Court and this court following its lead, how many times do you have to say we'll just do whatever they tell us to do? Okay. Continue to state that an exercise of police power protective of public health, safety, or welfare cannot be a taking requiring compensation. So again, for those people who had their house blown up by the police, it looks like you're out of luck because that would be police power protective of health. So that is not a taking requiring compensation according to this 1922 U.S. Supreme Court case. So sorry, but your house blown up looks like you're still out of luck. So, oh well. Thus, it appeared that some regulations of private property, were categorically incapable of being regulatory takings, but it's not clear which ones. Because our prior definition of regulatory takings was not based on independent state law, we need not decide whether it was incorrect and harmful. Instead, we can reconsider our precedent only when it has been shown, because two U.S. Supreme Court cases established that a federal legal underpinning of our precedent have disappeared. First, in 2002, the United States Supreme Court held that categorical rules are rarely appropriate in regulatory takings cases. The United States Supreme Court rejected that claim, cautioning, "We still resist the temptation to adopt per se rules in our cases involving partial regulatory takings. Instead, categorical rules for regulatory taking claims are appropriate only in extreme circumstance, such as where permit regulation provides no productive or economic beneficial use of land is permitted. In such extraordinary circumstances, there is no need for a case-specific inquiry because the regulation will always force individuals to bear a special burden that should be borne by the public as a whole. It is unlikely that Toho Sierra would recognize extraordinary circumstances are present whenever a regulation limits the right to choose with whom one will rent their property. If that were so, every anti-discrimination law that prohibits a landlord from rejecting a tenant based on protected characteristics would be a per se regulation requiring either compensation or invalidation. One per se category applies when governments require an owner to suffer a permanent physical invasion of property. The other applies regulations that are completely deprive an owner of all economic benefit of property. Any other regulation must be analyzed on a case-by-case basis according to the Penn's central factors. The plaintiffs do not argue that the first-in-time rule falls into a per se category, and it clearly does not. We therefore reverse the trial court and hold plaintiffs have not shown the first-in-time rule facially effects a regulatory taking of the property. The plaintiffs next claim that the first-in-time rule facially violates substantive due process, contending it's subject to heightened scrutiny because it regulates a fundamental attribute of property. We hold the applicable standard is rational basis review, which the first-in-time rule survives. We have always looked to federal law to discern the appropriate standard of review, and it's not been shown we should adopt a heightened standard now as a matter of independent state law. We therefore hold the substantive due process claim is subject to the same standard that would apply if their claims were based on due process clause of the 5th and 14th Amendment, which in this case is rational basis review, because it's not protected classes. The law regulating use of property violates substantive due process only if it fails to serve any legitimate governmental objective, making it arbitrary or irrational. This test corresponds to rational basis review, which requires only the challenged law must be rationally related to a legitimate state interest. Rational basis review requires the challenged law must be rationally related to a legitimate state interest. Rational basis review is highly differential because a court must assume the existence of any necessary state of facts which it could reasonably conceive in determining whether a rational relationship exists between the law and a legitimate interest. So you see how broad rational basis review is, right? Any rationale for any interest. It doesn't require a whole heck of a lot. The purpose of the rule is to mitigate the impact of implicit bias in tenancy decisions. It may well be the first-in-time rule will prove ineffective or unwise as a matter of policy. However, plaintiffs do not carry the heavy burden of showing it facially violates the substitute process. We therefore reverse and remand. So that is the case of Chong and Marilyn Yim versus the City of Seattle. In this case, we learned the City of Seattle passed a first-in-time rule that requires landlords to give a piece of property to any tenant who satisfies the conditions for rental property, and if there are multiple tenants who satisfy, you must give it to the first person in time. The purpose of this regulation is to prevent implicit bias. The Supreme Court of the state of Washington has said that this is not a problem under its state law because it has always applied the federal standard and has quietly overruled, 3 pages worth of precedent that may have said the contrary, but those no longer good law because we never said that in the first place. What cases are you looking at? We don't know. It's always been the rule. So I guess that is the case going forward, and tenants will be first come, first serve in the state of Washington, at least as it applies to the city of Seattle, and that is the end of this case.